Hello, my name is Ryan Ejim and I'm a student at Osgoode Hall Law School in Ontario. And in this episode of Case Law Minutes, we're going to be taking a look at the Ontario Court of Appeal case, Mattina and Mattina. This is a family law case that pertains to the subjects of costs arising from a custody and access appeal. Specifically, this case outlines modern family cost rules and the degree to which the family law rules cost awarding framework guides the appeal court's analysis on costs in family law disputes. As a disclaimer, this presentation is for general legal information only. For advice specific to your case, please consult a lawyer. With regard to the Court of Appeal decision, this cost decision contains a combination of cost submissions from a previous Superior Court of Justice decision to the Ontario Court of Appeal, along with a miscellaneous divisional court hearing. The appeal court ruled to dismiss the father's appeal of the lower court's decision. Subsequently, the parties made written submissions on costs of the appeal to the Ontario Court of Appeal, along with the cost of a previous attempt to appeal at the divisional court. The appeal court considered the submissions from both the mother and the father and awarded the mother her costs fixed at $25,000. This case will outline why the court decided to award costs the way they did. A brief history of this proceeding puts the cost issues in perspective. The father commenced this action in June 2013. In the course of the application, on consent of the parties, the court ordered a custody and access assessment under Section 30 of the Children's Law Reform Act. After the production of the initial assessment, followed by an updated assessment, the father's application was placed on the trial list. Upon learning that the hearing would unlikely be heard by June 2017, the father brought a motion seeking sole interim custody of the children for 90 days with no access to the mother during this period. The father also sought an order directing that during this period of interim custody, the parents and children participate in the Family Bridges program. In the alternative, the father sought an order for a directed trial on custody and access. In response to the father's numerous motions and applications, the mother brought a summary judgment motion seeking sole custody of the three children with access to the father at the discretion of the children. In September 2017, the motion judge granted summary judgment in the mother's favor. The motion judge awarded costs to the mother fixed in the amount of $80,636 plus HST. The father appealed that decision to the divisional court. The divisional court held that it did not have jurisdiction over the matter and transferred the appeal over to the Ontario Court of Appeal on an expedited basis. The costs of attendance before the divisional court were adjourned to the court hearing the appeal. After reviewing the aforementioned facts, the Court of Appeal began its analysis by outlining the general principles relevant to determining costs based on each party's submissions. With regard to the general legal principles of the case, it is important to note that Section 131(1) of the Court of Justice Act provides that cost orders are in the discretion of the court. However, Rule 24 of the Family Law Rules also sets out a framework for awarding costs specific to family law cases in the Family Court of Superior Court of Justice, the Superior Court of Justice, and in the Ontario Court of Justice. Although the family law rules do not expressly govern costs awards in the Court of Appeal, they have been used to guide the Ontario Court of Appeal's analysis on costs in family law disputes. The Ontario Court of Appeal has held that modern family cost rules are designed to foster three fundamental purposes: to partially indemnify successful litigants, to encourage settlement, and to discourage and sanction inappropriate behavior by litigants. The family law rules are a marked departure from some aspects of the rules of civil procedure. As such, case law pertaining to costs decided under the rules of civil procedure should be approached with some caution. Rule 24.1 of the Family Law Rules creates a presumption of costs in favor of the successful party of a motion, case, or appeal, and the presumption that a successful party is entitled to costs applies equally to custody and access cases. Consideration of success is the starting point in determining costs. This presumption does not, however, require that the successful party always be entitled to costs. An award of costs is subject to the factors listed in Rule 24.12, Rule 24.4, Rule 24.8, and Rule 18.14. Rule 24.12 sets out a list of factors the court shall consider in determining an appropriate amount of costs. It is important to note that the family law rules only expressly contemplate full recovery costs in specific circumstances. For example, where a party has behaved unreasonably, in bad faith, or has beaten offer to settle under Rule 18.14. Rule 24.4 addresses the situation in which a successful party has behaved unreasonably. Rule 24.5 provides guidance on how to evaluate reasonableness. In deciding whether a party has behaved reasonably or unreasonably, the court shall examine the party's behavior in relation to the issues from the time they arose, including whether the party made an offer to settle, the reasonableness of any offer the party made, and any offer the party withdrew or failed to accept. Lastly, Rule 24.8 discusses the cost consequence for any party who has acted in bad faith. Generally speaking, the Ontario Court of Appeal relied on the framework set out in Rule 24 of the Family Law Rules as guidance to award costs in this case. Now, moving on to issues. The two issues in this case are the cost before the Court of Appeal and the cost before the Divisional Court. The first issue in this case are the costs before the Court of Appeal, specifically whether the mother was the successful party upon appeal, which would strengthen her entitlement to costs. With regard to that issue, the court found that the mother was successful on appeal and is entitled to costs. This decision was made based on the ruling of the same court to dismiss all four grounds of the appeal made by the father. In this scenario, the mother is accordingly presumptively entitled to her costs. Additionally, the court addressed the application of Rule 24 of the Family Law Rules with regard to the amount of costs indemnified. After applying Rule 24 framework to both parties' submissions, the court did find evidence of unreasonable conduct by the father on his appeal, conduct which he should have known would increase the mother's costs. On the other hand, however, the Court of Appeal found the mother's conduct also impeded resolution by refusing to schedule a hearing and refusing to allow the father to file additional appeal materials. Lastly, the court addressed the costs before the Divisional Court and explained the father made an error due in part to a legislative deficiency. The Court of Appeal found that given this legislative deficiency, it would be unjust for the father to pay the mother's costs associated with the appeal before the Divisional Court. It is important to note that special consideration was also given with regard to the time invested by each party's lawyers. A large portion of the mother's preparation time had been spent on her lawyer's need to respond to the father's motion, which the court determined later that the mother's counsel made a reasonable proposal that would have avoided the necessity for such a motion altogether. Furthermore, the court also took into consideration the fact that the father's lawyer's services cost almost twice as much as the mother's, and found it reasonable to conclude that the father would have foreseen having to pay the mother's costs and that these costs could be significant. Thus, the Ontario Court of Appeal, having considered the reasonableness and proportionality of the relevant factors, decided that the mother should receive 60 to 70% of her costs, not including the divisional court bill from the Divisional Court Appeal. The mother had a bill of costs totaling $39,462.50. The court found it reasonable to award the mother 60 to 70% of her costs. Therefore, the court ordered the father to pay the mother her costs fixed in the amount of $25,000. That's the end of the case Mattina and Mattina. Now, if you'd like to read this case for yourself, you can find it on CanLee. And of course, if you're interested in more videos like this or other videos in this series, be sure to check out the Litigation channel and subscribe. This has been Ryan Ejim, and thanks for listening.